So let's start with the biggest question first. What is probate? Hi, I'm Dan Wheeler, Certified Probate Real Estate Specialist and CEO of All Things Probate DC, your one-stop shop for all your probate real estate needs. I help families, executors, and personal representatives navigate the probate process smoothly, efficiently, and with care. Whether you need help understanding timelines, marketing the property, or maximizing its value, All Things Probate DC is here to provide you with the expertise and support that you need to make this journey less stressful and to get you the best possible outcome. Now I know, if you're here, it's probably because you've already received your letters of administration and you probably already know what probate is. So let's go through some basics. If you recently filed a petition for probate or have been appointed a personal representative of an estate, this video is for you. Today, we're diving into what it actually means to open a probate estate in Washington, D.C. and what responsibilities lie ahead. If the decedent lived in Washington, D.C., their estate can be opened in the probate division of the Superior Court. This is necessary if the decedent owned real estate in Washington, D.C., other assets in their name alone, or if you need to access medical records or documents for potential litigation. Now, assets that are jointly owned or accounts with designated beneficiaries typically don't go through probate. Probate is typically for assets solely in the decedent's name. If the decedent left a will, the original document must be filed with the probate division. The individual named as the personal representative in the will has the priority to petition for the probate and to manage the estate. But what if there's no will? In that case, the next of kin, such as a spouse or a child, has the priority to file the petition for probate and to serve as the personal representative. You may have heard this role called the executor or the executrix. Once you receive your letters of administration and are appointed the personal representative by the court, your responsibilities officially begin. Here's a quick overview of what you'll need to do, and throughout this series, I'm going to go through each one of these and break them down in more detail. But for now, here's the bird's eye view. 1. Collect the decedent's assets. This includes bank accounts, real estate, and personal belongings. Next, address claims and bills. You'll resolve outstanding debts and pay any estate-related expenses. Third, communicate. It's important to keep interested parties informed about the estate's progress. 4, file tax returns. The decedent's final tax return must be prepared and filed. 5, submit an inventory and account. You'll prepare detailed documentation and a final account for the courts. And 6, distribute the assets. Finally, you'll ensure that rightful heirs and beneficiaries receive their share of the estate. Now, this entire process takes time. Depending on the caseload here in DC, from the time the petition for probate is filed to the time that you receive your letters of administration, I've seen it take anywhere from a week to 6 months. And it really just depends on the complication of the estate, the heirs, the beneficiaries, and the outstanding debts and interested parties to the estate. The timeline allows for proper collection of assets, resolution of debts, and court oversight of the estate's administration. Navigating probate can feel overwhelming, but with the right guidance, you can fulfill your role as the personal representative with confidence. Stepping into the role of personal representative is a significant responsibility, and starting off on the right foot is crucial. There's lots of mistakes that you want to avoid, and by avoiding these common mistakes, you'll set yourself up for a smoother probate process. And if you want to know more about the 3 mistakes to avoid, make sure to click here because it's coming up right